Welcome to today's webinar, Looking Out for the Baby Boomers. Are you protecting your senior clients and your firm? Before we get started, I'd like to go over a few housekeeping items so you know how to participate in today's event. We've taken a screenshot of an example of the attendee interface. You should see something that looks like the image on the left on your own computer desktop in the upper right corner. You're listening in using your computer speaker system by default. You will have the opportunity to submit text questions to today's presenters by typing your questions into the question pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. I would now like to introduce our panelists, Bill Riley and Andy Favret. After a 30-year career with the Florida Division of Securities and Office of Financial Regulation, Bill Riley now provides essential compliance services to broker-dealers, investment advisors, and industry professionals by leveraging his examination expertise and relationships with regulators and self-regulatory organizations. Along with assisting industry firms as they develop policies and procedures, Bill also provides in-house firm training for dealing with vulnerable adults and senior clients. Andy also has 30 years of experience in the financial services industry. Prior to working at Oyster, Andy served as regional chief counsel in FINRA's South region and was associated with Deckert LLP, an international law firm with a specialty in financial services. His experience at FINRA included negotiation and litigation of a wide variety of regulatory matters and drafting and review of FINRA rule proposals. Andy's most recent experience at Oyster has included engagements as a compliance consultant and an expert witness in both federal, civil, and criminal litigation, as well as in a FINRA arbitration. Bill and Andy, I'm going to let you take it from here.
Thank you, Libby, for that introduction. And I would also like to welcome our audience this afternoon for what we believe to be a very informative webinar involving a very popular topic at this time. And again, that is dealing with senior and vulnerable adult clients. Now, during our presentation today, we are going to be talking about 5 or 6 different areas. One of those is, why is there an increased focus from regulators and from the financial industry regarding senior and vulnerable adults? We're also going to talk about amended Rule 4512, which will take effect in the first week of February. We're also going to talk about new FINRA Rule 2165, which again will also take effective that date. And another concept that is used in connection with these rules and also with state regulations in this area, and that's a concept that's called a trusted third-party contact. So we'll discuss that. The next area that we're going to discuss is a very important area, one area that I think is one of the most important areas, and that is establishing escalation procedures when issues such as cognitive impairment are discovered by registered reps or investment advisor representatives, and to have a policy and a procedure whereby those instances where these issues come into play, there's a way to move it from the investment advisor rep or the registered rep to the compliance and or legal department. The next area we're going to talk about is identifying impairment and financial exploitation. There are definitions within both the FINRA rules and also within the state rules that identify impairment and also discusses financial exploitation. So we will walk you through those processes. We're also going to talk about a little bit about the state regulations that have been in existence for a number of years. And then the last part of the presentation, we're going to talk about some recommendations that and some areas that we've seen that are key to these new regulations and these new processes, and we hope these will prove useful to you. One of the topics that we're going to start with is the reason for the increased regulatory focus. And it's, this is something that is not new. People have been talking about, the aging of America over the last, 10, 12, 15 years. And now we are here. We're finally at that point where, starting in January 2011, 10,000 baby boomers, and baby boomers are those people who were born at the conclusion of World War II until the mid-1960s. One other point that's very important is that the average U.S. life expectancy has gone from 68 to 79 years in basically the last 60 years. Okay, And the thing that's also important is that the standard of living of people is not only are people living longer, but they're living more quality life than they were 50 to 60 years ago. Another critical point is that substantial number of women that are aged 65 to 75, 27% of those women lived alone. 42% of the women that are 75 to 84 lived alone, and 56% ages 85 and older lived alone. So what we have is we have what is generally referred to as the trusting individuals out there, and based upon that, they have been a little more vulnerable to security scams and other types of problems. The number of Americans living with one of the most common forms of cognitive impairment, and one of the better known ones, is Alzheimer's disease. The number of people with Alzheimer's disease could increase from 5 million in 2013 to approximately 14 million in 2050. That's a substantial amount of people that may be suffering from that disease. And one other thing, I don't think this goes without saying, is that the vast amount of net worth held in this country are held by people that are 65 and over. So if you take a look at the situation, you follow the money is with the people that are 65 and over. And as a result of that, there will be increased regulatory focus on these various groups that I've talked about. Andy?
Hello. Once again, as Bill suggested, we're glad to be here with you today. I want to talk a little bit about the two new FINRA rules, which are set to go into effect on February 5th. They were both announced last March in FINRA Regulatory Notice 1711, which suggests that FINRA, at least, has given firms a considerable amount of time to adjust their procedures and prepare for the rules. And as we'll discuss later in the presentation, I don't think there's any question that FINRA is going to be on the lookout for how firms are beginning to comply with these rules. The two new rules are themselves really just an evolution in FINRA's ongoing focus on protecting senior investors, which goes back at least to 2007 when they issued a regulatory notice on factors that firms need to take into account in dealing with senior investors. And I think based on Bill's discussion of some of the demographic statistics, it's not at all surprising that both FINRA and other regulators are really ramping up their focus on this area of the population and on firms' efforts to protect them. At our webinar that Bill and I did for Oyster back last May, we touched on the fact that FINRA had already put into place a senior hotline to report on exploitation of seniors. That's been highly successful and highly touted by the regulator. These two rules that we're going to talk about today really need to be read together because they work hand in hand. There's a lot of cross-reference in the two between putting holds on disbursements in customers' accounts and involving the trusted contact person. So we're going to talk a little bit about the first rule, 2165. We're going to talk a little bit about amended FINRA Rule 4512. That rule provides that firms must make reasonable efforts to obtain the name and contact information for a trusted contact person when updating or opening new non-institutional customer accounts. It does not prohibit the opening an account when this information is not available. However, the firm does need to document properly that the effort was made. So what this means in reality is if for whatever reason a firm is unable to obtain such information, and that could be based on the fact that the customer doesn't want to provide it to you, there's nothing to preclude the firm from going ahead and opening the account anyway, but the effort needs to be made. We'll talk a little bit more about some of the intricacies of when this effort needs to be made, but at least at this point, focus on the fact that when you're either opening an account or updating an account, that's when the effort needs to be made. Most states already have this trusted contact person regulation or some variation of it in place, we're going to see later about how firms can kind of model their adherence to the FINRA regulation on what they may or may not already be doing with respect to the states. Because the concept of a trusted contact person is so important to the implementation of amended FINRA Rule 4512, we thought we'd spend a little bit of time today talking about the ins and outs of how a firm puts their procedure into place. First of all, we recognize that this is a sensitive topic. When you approach a customer who either is elderly or is getting to the point where they may be elderly, it's a tough conversation to have because essentially you're suggesting to the firm that you're reaching out to the customer, that you're reaching out to them to get the identity of a trusted contact person that could back up their own independent judgment. Therefore, one of the things we recommend that you do is have the conversation as early as possible. There's nothing in the rule that suggests that you can't get the name of a trusted contact person at any point in the existence of the account. And doing it with a customer who is 40 or 50 years old may be a little less threatening than going to someone who's 65 or 70-year-old, or especially going to a customer who you already suspect may be having problems with impairment. When should you do this? Ideally at account opening. The rule requires that if you're opening a new account, you make the attempt to get information about the trusted contact person. Otherwise, you're supposed to get it during the periodic account review, which isn't mandated by FINRA at any particular time, but SEC Rule 17A3 requires it at least be done every 3 years. We'd suggest that after the implementation of this rule next month, firms should really go about trying to get trusted contact person information for every account, or at least every non-institutional account, as soon as possible. The other question is, why do this? Well, obviously the FINRA rule anticipates that this requirement is in the interest of the customer. But more importantly, the rule makes clear, and we'd like to make clear, that the rule serves in the firm's best interest. If you go back to the regulatory announcement last March that announced this rule, they came up with a number of instances where a firm might want to use trusted contact information to safeguard handling of a customer's account. For example, if a member's been unable to contact a customer after multiple attempts, you could contact the trusted contact person to inquire about a customer's current contact information. If a customer is ill or infirm and therefore unavailable, again, you could reach out to the trusted contact person to inquire about the customer's health status. A member could also reach out to a trusted contact person if there is concern or suspicion that a customer is suffering from Alzheimer's, beginning to suffer from some sort of dementia, which, as we know, is a progressive disease and not necessarily something that's going to happen overnight. And finally, a member could contact a trusted contact person if there's a suspicion that financial exploitation is occurring in the customer's account. So there's any number of reasons why having trusted contact information is really in the firm's interest as well as in the interest of the customer. Let's talk a little bit about best practices. Bill, could you tell us a little bit about that?
Yes, thank you, Andy. I think most regulators and industry professionals know the importance of, in addition to having rules and regulations, the importance of having best practices. So one of the things that we've done as we've kind of moved through this whole process, and when we've spoken to clients of ours, is we've come up with a list of best practices that as an account progresses and as a person moves from having an account opening and then moving closer and closer towards retirement and then actually getting into retirement, I call this screen the conversation. Some of the topics that are on this screen are very difficult and sometimes very hard to have a conversation with a client. But we do think that it's important to have these conversations and make sure that everyone's on the same page. We also recommend that when you have a conversation with a client on these topics, it's a good idea to have a family member or a trusted financial professional present during these meetings. So the things that we want to talk about, does the client have a will? Is it current, or is it years and years old? So we want to make sure that there's a will, that it is current. We want to make sure that if they need a power of attorney, that it clearly spells out who has the power of attorney and how the power of attorney can be implemented. The other thing we want to talk about is with the client is make sure we have a clear understanding who is the beneficiary. Is it one person, two persons? Is it an organization? And more importantly, we want to make sure that as we have these meetings with clients, that we continue to go through this to make sure that there hasn't been a change. And if there has been a change, we want to try to have a good understanding as to why there may have been a change in a beneficiary. Changing of beneficiaries many times occurs as a person ages, and sometimes as cognitive impairment may start to set in. So we want to make sure that that information is accurate. Does the person have a trust? First question is, do they need a trust, and so forth. So we need to have that discussion. We also need to make sure that the terms as to who the trustee is and about moving forward, when there is an event necessary to have the trustee take over, that it's clear as to the objectives of the trust. The next item is something that's relatively new in the last 10 or 12 years. We're probably dealing with healthcare and extended care. If a person does have one of these incidents where they have some sort of impairment, whether it's specifically Alzheimer's or another type of impairment, how are they going to be cared for? Are they going to be cared for out of the home? Are they going to be cared for in one of these assisted living facilities? So it's very important to determine what will happen should there be some sort of impairment. Okay, and now let's talk about the final arrangements. And what we want to discuss here is that when a client passes on, what we're talking about here are the final disbursements from the estate. To make sure we all have a clear understanding as to how that will proceed. And I think now what we'll do is we'll turn it over to Andy, and we will talk about new FINRA Rule 2165.
Thank you. The new rule really provides firms more of a compliance challenge than the amendments to 4512. New Rule 2165 allows firms to place a temporary hold on disbursements from a customer's account if they suspect that there is financial exploitation or impairment. There are a couple of key things to note here. It does not require that a firm place a temporary hold. It just gives them the opportunity to do so, essentially providing a safe harbor from other FINRA rules which would otherwise require a firm to promptly execute a customer's order. The safe harbor provisions of 2165 are triggered when a firm has reasonable basis to believe that the customer is suffering from physical or mental impairment or that financial exploitation may be occurring. It applies to specified adults, and those are defined as individuals 65 years or older or 18 years or older if there's suspicion of impairment. It requires that you provide notice to the customer within 2 days for why you are placing, for the fact that you're placing a hold on the disbursement. It also you need to provide all parties with authorization over the account with notice, which may include a trusted contact person, unless there's suspicion that the trusted contact person is the one that's doing the exploiting. One key thing to note, and it's been highlighted in a number of FINRA pronouncements, is that this hold only applies to disbursements from a customer's account. It does not apply to securities transactions. So, for instance, if a customer calls and wants to buy or sell a security, even if there's suspicion of financial exploitation or impairment, the rule does not go so far as to allow a firm to place a hold on that, only on disbursements. Where it may come in, though, and the the guidance on this is made clear is if there's an order to sell securities and then transmit proceeds, the transmission of the proceeds would constitute a disbursement and therefore could be subject to the hold provision. Some of the other things about the rule, it includes a broad definition of what financial exploitation is or may be, and the question obviously is how is a firm going to define this internally? Right now there's not a lot of guidance given on that, and I suspect that what's going to happen over the next year or two as the rules kind of implemented across the country is that there'll be some more guidance about examples of where financial exploitation is actually occurring. It does apply to ACATS transfers, so if there's a concern that someone who's impaired or being exploited is moving an account from one place to another, that would essentially constitute what FINRA terms a disbursement, and firm would be allowed to place a hold on that. The other things we've talked about with respect to this are the identification of who in the firm is allowed to make this determination, how's it going to be escalated, how's it going to be reported, and what kind of training takes place. So let's turn to our next topic on this, which is the escalation procedure, or excuse me, the disbursement hold itself. Firms are going to need to focus on, if they have not already, determining the responsibility in-house as to how the placement of a hold is going to take place and who's going to be able to make that determination, how it's going to be terminated, and when or under what circumstances it will be extended. The rule provides that a hold may be placed for up to 15 days unless a state agency or other regulatory authority asks that it be extended. But obviously it could be terminated even sooner if the firm makes a determination that the hold wasn't necessary or was no longer required. How that's going to be done, who's going to have the ability to do it, needs to be a focus of a firm's procedures, and obviously it's going to vary from situation to situation. Firms are going to need to establish escalation procedures, and this is probably the most complicated part of the new rules requirements. Firms, if they haven't done so already, will need to designate a person or a section within the firm to receive the escalation. Obviously, it will involve principal review. When to escalate and to whom. Documentation is key for all of these determinations, both when the hold is put into place and when it's finally determined that a hold is no longer necessary, or however the hold is finally concluded. All of that will need to be documented. What's the nature or the mechanism for a registered rep having discussions with compliance? When will it take place? How is the decision made to report, and to whom is the decision made? What kind of follow-up is going to be required with state agencies or law enforcement or judicial system? It's noteworthy that FINRA does not require this, but a number of state laws that intersect with the FINRA rules will suggest that there needs to be follow-up, oftentimes with state agency or law enforcement. And finally, what the resolution is going to be, whether the hold is extended indefinitely, whether it's terminated, however it's resolved, and that all needs to be documented. I think we would all agree on the call today that to sort of arm yourselves against inquiries from regulators, FINRA in particular, the best thing to do is to document all of this carefully. And just a note here, I think as FINRA begins its 2018 exams, it's not at all surprising that they're going to be focusing on this area, and what they're going to be focusing on primarily at the outset is whether firms have updated their procedures, whether they have had instances where holds have been put into place, and the extent to which they're documenting this. Those are going to be easy areas for examiners to key on. The actual determination is probably not going to be as crucial as the procedures that have been put in place to make the determination. So I would guess that FINRA is not going to be second-guessing attempts that were made to put holds on accounts, or even determinations made not to put holds on accounts, but they are going to be very interested in seeing whether it's been documented within the firm and whether the firm has procedures in place that were followed. So with that, Bill, let's turn to some discussions about what, oh well, before that, let's talk about the frequently asked questions. Very recently, on January 3rd, FINRA issued frequently asked questions. They're available on the Oyster website. They're obviously also available on FINRA's website. These are in response to inquiries that FINRA has been getting over the last several months since these new rules have been announced. There are a number of sort of in the weeds kind of discussions there, but I thought we'd focus on 2 or 3 of them here. One of them, with respect to the disbursement holds, makes a distinction between a total and a partial disbursement. And what this means is that if a determination is made that a customer may be impaired and that therefore a hold is appropriate, it may also be appropriate that certain disbursements out of the account are not suspicious and can go on. So for instance, if there's a concern about a large monetary disbursement to a family member, but at the same time there are other disbursements being made to pay utility bills or the mortgage, the firm can place a partial hold on the account on the particular disbursement to a family member, but continue to make disbursements to pay bills that are routine. So it's not necessary to freeze or shut down the entire account, and in fact may be inappropriate to do so. There's also considerable discussion about who in fact may or should be asked to be a trusted contact person. And FINRA makes it clear that the only real requirement under the rule is that they be over the age of 18. Beyond that, it can be anybody. It could be a family member, it can be a lawyer, it can be somebody who already has power of attorney over the account. It's to some extent up to the customer to make the determination. There's no restriction as to who the trusted contact person should be. And some recent guidance from FINRA suggests that there can be more than one trusted contact person on a particular account. Similarly, within the frequently asked questions, there's been a determination made that you can have one trusted contact person for more than one customer account. So if a customer has multiple accounts at the firm, it's only required that the firm make efforts to get trusted contact person information for one of those. And then finally, what may be discussed to the trusted contact person. Obviously, there's some privacy concerns here. What the FINRA fact, the frequently asked questions, make clear is that adherence to the rule will absolve the firm of liability with respect to Reg SP, and they really open the door wide open to the types of discussions that you may want to have with a trusted contact person. We've touched on several of them before, but they could have to do with the customer's whereabouts, a particular determination made that the customer is making about the handling of their account. It could certainly be made with respect to disbursements or planned disbursements out of the account. Once again, the rule requires that you provide notification to the customer that you've established who a trusted contact person is, but there are very few restrictions placed by FINRA on the nature of discussions that can be had with a trusted contact person. And we really see this as a boon to firms who want backup sometimes before making determinations about how to handle an issue in a customer's account, especially in an elderly customer's account. So Bill, why don't you talk a little bit about the state regs and how they intersect with these new FINRA rules?
Well, thank you, Andy. One of the things that I'd like to discuss on the state regulations, and it's very clear, and this will kind of track Andy's conversation about the FINRA rule, which is taking effect in just a couple of weeks. There are a substantial amount of commonalities between the upcoming FINRA rule and some of the state regulations, but some of those regulations being around for 4+ years. So we do have a little bit of some track history of, kind of what we have seen among firms and, certain escalation processes, reporting processes. But the differences are, and the thing that I'd like to mention at this time is that the state regulations, and we'll talk about the number of states that have adopted those so far, but most of the regulations are based upon a NASA Model Act that was passed by the NASA membership in January of 2016, so with the exception of a few that were enacted prior to January of 2016. They are based on the NASA model rule, but some of the major differences is that the regulations pertain to both broker-dealers and state and federally covered RIA. Okay, Andy mentioned that the FINRA regulation puts a senior person at age 65. Okay, the states range. Some states are 60, some states are 65, and one state that adopted in 2017 puts the senior age at age 70. So there is a bit of a variance there. The other difference, and Andy kind of touched on this, is that the state regulations provide for reporting of the financial expectation to state securities commissions, adult protective services, if instances require or suggest to law enforcement. And the important point that I want to mention here is that the reporting to either the State Securities Commission or the Adult Protective Services Agency and the client's state of residency, the reporting may be mandatory or voluntary. It's probably spread out about half and half as to what's out there. I will say this, though. I have spoken to a number of adult protective service agencies around the country, and the representatives I've spoken to have strongly suggested that if you do have financial exploitation and there needs to be some involvement at the adult protective services level, even though it may be voluntary, they strongly suggest that a firm make some sort of filing with that adult protective service agency. Let's go to the next screen, which will kind of show us a map here. And the map on the left shows the number of states in really at the beginning and into 2016 that had adopted regulations for disbursement hold. And I think the number in 2016 is 7. The number as of January 1st of 2018, as you can see on this map, is now 17. I've also heard situations where a number of states have introduced legislation in early this year for consideration of adopting of disbursement hold regulations. And we'll see where those states go. I think I've seen a handful, and as we move further into 2018, I anticipate that that number will increase. But one of the things that's really important, I think, in this area, and if we can maybe move to the next screen, where we'll talk a little bit about the reporting. So what we have is again, at the state level, broker-dealers and investment advisors have reporting requirements. In some situations, you may have a state securities commission that has a mandatory requirement, and the Adult Protective Services Agency that has a voluntary. How does one keep track of what the reporting requirements are, what the number of days? Because the reporting to these various agencies, whether it be a state securities commission or adult protective services, all have, and where there is a mandatory reporting requirement, all are driven by certain time frames. So it's very important to know, number one, what states are mandatory reporting and which states are voluntary, and what the amount of time frame for reporting it. But as Andy also talked about, the periods of time under which a disbursement hold can be initiated and a disbursement hold can also be extended. So the thing that we recommend in this situation, you need to have some sort of matrix, and it just so happens that Oyster has created a matrix, and it has proven very useful to clients of Oyster as they determine what the reporting requirements are. Because if you do not have a matrix, every time you turn around and you find out, does a certain state have a requirement? Is it voluntary? Is it mandatory? What are the number of days? How far can I extend this hold before I have to release it? So it's very important to try to have some sort of matrix available to you that you can use on a day-to-day basis to determine how to move forward. And let's go to the next screen, and we're going to talk a bit about enhanced senior client account reviews. One of the things is clear is that as a after accounts are open, most of the time, Andy mentioned earlier about the 3-year account requirement, based upon SEC Rule 17A3. But I think it's also important, that's something there about updating information and confirming. But I think what happens is during the life of an account, there's also, interaction between a registered rep, an investment advisor rep, and the client. So one of the things as a client is moving towards at retirement or in retirement, some of the best practices out there are to look at increased frequency of meetings, whether it be, in person, on the phone, and so forth. So we would suggest maybe semi-annually or when necessary. The other thing that's also important is when you're talking with your senior clients, like I said, that are close or in retirement, does the firm have certain restrictions on the sale of certain products, those that may be less transparent and more risky to a senior client? Does your firm have product restrictions? Does it say only a certain amount of a product can be held in any account? Does it prohibit certain types of securities being held in retirement and accounts where people are retired? The other thing that's also important is, I think, to take a look at to conduct a portfolio review. Are the securities that are in that account, are they appropriate for a senior client? Now, one thing that I also want to caution is that you do not want to broad brush, looking at this client account review, because you may have clients that may want to have certain securities or take a certain amount of risk. So no client is exactly the same. But I do think it's important to do a portfolio review on an ongoing basis. The other thing that's also important is to determine investment objectives, risk tolerance, and time horizon are in fact accurate. I mean, as a person moves from working a full-time job into retirement, and they may even relocate to another state or something like that, that's all going to have an impact on the objectives, the risk tolerance, and time horizon. So it's important to make sure that those items are in fact accurate for the account, and to continue monitoring those, and when life-changing events occur, to make adequate adjustments. And while you're having these conversations and with the client, one of the things you're going to be doing, and many of these are going to be, and we would recommend many of these be face-to-face, you're going to be evaluating that client for cognition issues. Maybe you had a review with a client 6 months ago, and now you're talking to the client today, and you notice that things just aren't quite right. There's a few things that are different there, and we're going to talk about signs of impairment as we go down the road. But one of the reasons for having these enhanced and more frequent client account reviews is to determine whether or not there have been any substantial changes in the way that the client holds themselves out. So it's very, very important to, and as we talked about before, when escalation occurs, document, 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 because all this information is going to be very important when you escalate this up to your compliance and or legal people, or whatever section you have out there that takes these kind of cases. They're going to ask you for that documentation. So now we're going to move over to the next screen. Andy?
During our May webinar that we did on senior exploitation, we focused on behaviors by customers that might be red flags about impairment. This time what we're going to do is focus a little more on account activity that may serve as a red flag for impairment. And there are a number of examples here, most of which are kind of self-obvious, but all of which should sort of be duly noted in firms' training or their procedures. Change of a client's account address. And FINRA has brought numerous enforcement actions over the past many years that involve somebody exploiting a customer by directing or redirecting account statements to another address. So that's something to be on the lookout for, especially if there's no real good reason for the address change. Withdrawal of funds or transfer of assets, which is essentially implied by the entirety of the new Rule 2165, changing an account beneficiary. Again, especially if the account beneficiary has been a family member or a spouse for the last many years, and all of a sudden is changed to someone for whom there's no real ready explanation. That's worth a follow-up or a second look. When authorized signers are added to an account, again, very often you've had a situation where either one trusted person has got signatory authority over an account, a child or a spouse, and all of a sudden somebody new comes into the picture that the firm's not familiar with, but there's no good explanation. A change in a will or other financial documents, that may not be something necessarily apparent at first glance to the firm, but if there are documents that the firm has access to, say for instance investment objectives go from being conservative to wildly speculative, and all of a sudden there's increased activity in the account, that's certainly a red flag. Sudden appearance of previously uninvolved relatives, if all of a sudden during your conversations with a client there are new people on the phone that you are not familiar with or never had dealings with before, and it's not readily apparent what the familial connection is or the connection should be, that's something worth taking a second look at. And all of these, certainly this one in particular, would be a ripe opportunity to get in touch with a trusted contact person. Again, it's a good example of how these two rules sort of dovetail with one another to say, you know, recently trusted contact person, there's been involvement by relative or neighbor or friend XYZ. Who is this person? Is this legitimate? It's worth a second thought. These are just a few examples of the kinds of situations that firms can be aware of, and certainly that can be built into firms' training modules for this as they prepare for the implementation of these two new rules. And Bill's going to talk a little bit about training.
Thank you, Andy. One of the items that has been at the forefront of this issue for a long time now, for many years, you know, with or without the disbursement hold regulations and so forth, is training. It is paramount. I've looked at a number of issues that have documents that have been published by regulators and so forth, and training is paramount. So one of the things that we recommend is that when you're looking at this issue, and one of the things I also want to indicate, that as I said before, you know, some of these states have had these regulations out there for a number of years now. So it is imperative that, and also with the upcoming, you know, FINRA regulations in February, it is imperative that if you don't have training, you need to gear up very quickly. And when you're looking at training, of course, there's a number of items here that we recommend that you engage in. And of course, the most important one is conducting a needs analysis. And one of the things that you're looking at is in determining the intensity of a program like this for seniors and vulnerable adults is, what's your customer base? Is there a very small portion of your customer base that has senior and or vulnerable adults? If you have a very high percentage, then you would need to design a very intensive program, you know, for your registered reps and or investment advisor reps. The other item, and I touched on this just a few minutes ago, the product mix. You know, there are certain products that at least at first blush or first review would be very appropriate to be in a person's account that is at or in retirement. We need to look at, what's your product mix and, structure some training around products that would in most situations be appropriate for senior accounts. The other question is, who do you train? And I think one of the big items here is your client-facing personnel. And what we're talking about here is if you're in an office, a branch office or home office, your receptionist, your registered rep or investment advisor rep, your supervisors, and your branch managers. Also, that you would also need to look at, what type of training would be appropriate to provide to your back office people or operations people. And then the third level of that is determining the people that are in your compliance department or in your management area. What type of training. So what you may have is there are a lot of firms out there that have a small number of registered reps, investment advisor reps, and compliance people. May be able to have a program, have one type of program, whereas when you're looking at a very large firm with thousands and thousands of reps, you may look at a three-tiered type of program: your client-facing, your operations, and your compliance and management. So the training really depends a lot upon your product, your customer base, the size of your firm, and then the next item that you come to is the timing. What intervals of time are you going to provide training? I think it's clear that training needs to occur at least annually, and many times when firms do their annual training, they will cover this topic. My suggestion, and a suggestion of Oyster, is that since we are now moving into the FINRA regulation and more states are adopting the NASA-based regulation, it may be important that if you've already not delivered this training, that you deliver this training very early on in 2018. And I think it's also very important that when new staff come on board, and again, whether it be client-facing, operations, compliance, or management, that the training be delivered as soon as possible after their onboarding. So that's also very important. The other thing to continue to discuss, and we've already kind of touched on this, does your firm have hundreds of branch offices, or do you have one single office? So I think what's important is for the firm to make a determination: am I going to deliver this electronically? Am I going to deliver this, via the internet or some other social media type of presentation, or am I going to deliver this in a classroom style? So I think it's very important, to make sure that that you determine, the method of that. I also think one other point that's also important is the firm needs to have some sort of program that will allow it to monitor the progress made by these various groups of people. So, one of the things that when a regulator goes in or there's some sort of, internal audit going on that should be asked for, is to ask for some sort of documentation as to the progress the personnel at the staff are making in completing and addressing training for seniors and vulnerable adults. Let's move to the last screen. And what we really would like to do is just to let you know how Oyster can help as you and your firms move through these processes. We've had experience over the last year with with getting ready for the implementation of the FINRA regulations. As I've also discussed before, we have had experience in the 4+ years that the state regulations have been around, and Oyster stands ready to help you on any of these areas that are listed on the screen.
Thank you again, Bill and Andy, and thank you everyone for attending today's webinar. We want to be mindful of everyone's time, so we'll stop here. If you have any questions, please contact Oyster Consulting through our website at www.oysterllc.com or by phone at 804-965-5400. And one of our relationship managers will be happy to help you. Thanks again.